let me just give a brief introduction about yourself, ma'am. So I'll and then I'll hand over this meeting to you, ma'am. আমাদের স্টুডেন্টস জয়েন করছে, তো আমি জাস্ট 1-2 মিনিট আর
ওকে
ওকে। Ma'am, within next 1 minute we will start.
Okay.
And after, give a brief introduction about yourself, and then I will hand over the session to you, ma'am.
Okay.
Ma'am, so should I commence this session?
Yes, of course, you can do it.
Okay. Good afternoon, everyone. So before I proceed further, let me just ask one thing. Is it, am I audible and am I visible?
Yes, you are audible and both.
Okay, thank you, Gopal sir. So good afternoon, everyone. So today we have joined here for the session for a webinar on how to file a patent, and to deliver a special lecture on this, we have Dr. Jayati Biswas with us. I request all the participants to mute yourself. Please mute yourself. Sorry for the inconvenience. So let me just give a brief introduction about Dr. Jayati Biswas. Dr. Jayati Biswas has completed her graduation and master degree in chemistry from Benares Hindu University, and then she pursued her PhD from Jadavpur University, followed by a postdoctoral research fellowship. She has worked in various industries and engineering colleges, including our very own GIS group also, for more than 12 years. Currently, she is working as technical associate at Anjan Sen and Associates from Kolkata, handling various technical dealings from there. So, ma'am, I will not take any more minute, and I'm hereby handing over this session to you, ma'am.
Okay. Thank you, Sandeepan. And so I have already, Sandeepan has given a very good introduction. Okay. So still I see students waiting. So I think it's, I'll do it. I'll start my session. I think, Sandeepan, can you take care of, I mean to say, admitting the students? Because
yes, please. Okay. It will be our part. It will be our part, ma'am. So please, please go for the session.
I'll start off with how to file a patent. I think I'll just start off with a slideshow, and 1 minute. Okay. So today I will be giving a brief lecture about how to file a patent. Okay. Now, before going into the details of how filing a patent, first and foremost, you should know what is a patent, isn't it? Now, it is a type of, intellectual property right. That is, you have a legal right. Right over what? Right over all the innovative ideas that you have. And you have used those innovative ideas to actually go for to have an invention, okay? Or your idea, your innovation has created a technical advancement which was not there before in the public domain. So these things are protected by a legal right, which is called a patent, or it comes under intellectual property right. So very simple, in a very simple way, I can just tell you whatever ideas, whatever innovative ideas, whatever good ideas you have, okay, regarding science and technology, if you put it into action, okay, and those actually are giving you results, that right, that particular idea can be protected by this intellectual property right. Okay. Now going to the, I have seen across many people, they confuse between what is a patent, what is a trademark, what is a copyright, and especially I have seen people actually, they are using copyright instead of patent, patent instead of copyright. So, there is a hairline difference between these three. So first, let us understand what is the difference between a patent, trademark, and copyright. So patent, it gives you an exclusive right over your inventions. Inventions in the field of science and technology. Please, nothing literary, okay? So all inventions in the field of science and technology are protected by this law, or if you file a patent, that will be protected for a certain period of time, that is 20 years. So for 20 years, your innovation, your invention will be protected. That means if anybody wants to use your invention, he or she has to take your permission. Okay. So the patentee, the person who have been already granted a patent, that person gets the right over his or her invention for a period of 20 years. Now coming to copyright, if you just see the copyright here, I think the trademark is not visible here. Are you able to see the trademark part?
Yes, ma'am. Yes.
Are you able to see it? Because the screen is getting guarded, I think. Anyway, so the copyright, it is an exclusive right over authorship. What is the meaning of this? Something creative. Okay, all your creative work will be protected under this right, copyright. Okay, so the creative work may include something compositions in music, in dramatics, in cinematographics. Okay, so all the literary works or artistic works, your photographic, any invention, photographic, related to photographic domain, it will be protected by copyright. And generally, the copyright is giving the protection till 60 years, 60 years. Okay. Coming to trademark. Now, trademark, it is a bit different. Like, I think trademark, I think you will be quite conversant with the trademark part. Why? Because I think you've heard the name of branding, isn't it? Always you have heard that brand, it has to be branded. Trademark is a word, a phrase, or a symbol, or a logo. Okay, it is big companies, they have all the giants, multinationals, they have a trademark logo. I think all of you know that, you have seen that also. Suppose, why do we need that? You will find now that the local manufacturers, you will find a lot of local manufacturers in this market. They are going to manufacture a product, and then finally they will go under an umbrella. What is that umbrella? Giant multinationals. Okay, they'll go there. Why? For branding, for creating a trademark. That means under that umbrella, that becomes the trademark of that particular person. and then they want to actually market that product. So this becomes your trademark. Okay. Then coming to, now before going into the detail, I would like to just tell you what are the 3 prerequisites of patent. Okay. So the patent, the first requisite of patent is novelty. That is, it should be novel in its nature. That is, it should not exist in the public domain. Okay, do you get it? That means, what is the meaning of public domain? Like, you know, just 1 minute. Just 1 minute. Okay.
Any issue?
Yeah, okay. So what does it mean? That suppose, you know, something which is new, totally new, like, you know, you may have invented a kitchen appliance, okay, which helps you in, or which assists you in kitchen, cooking. Now what happens? You share it among your friends, okay, and then one fine day, one of your friends advise you that you should get it patented, and then you go for patent. No, it cannot be like that. The first invention, if you invent any product, okay, any process or any product, it should be patented first. Is it clear? So it should not go into the public domain. Then, you know, very important fact, that is, it must be non-obvious. That is, it should have inventive features. What is the meaning of inventive features? That it should be non-obvious. What is the meaning of non-obvious? Like, you know, suppose you prepare a food and you put a lot of salt in it. So what will happen? That food will definitely become salty. So this is an obvious thing. If you put salt into something, it will become salty. If you put sugar into something, it will become sweet. So these are all obvious things. This cannot be patented. So along with salt, if you have put some other kind of masala, whatever you find, and then you give it a different taste, that part can be patented. So something which is obvious cannot be patented. Like, you know, if you talk in terms of chemistry, since I'm in the field, from the field of chemistry, I would just say, I think all of you have studied in your class 12 about the halogen group. Okay. Now what happens? Suppose you're using chlorine in particular experiment. Okay. And you are getting a new product. So another person from this field only, that is from chemistry, he may see or she may see that, okay, he has used chlorine, why don't I use bromine? But, you know, this cannot be patented. Why? Because they are in the same group, and it is very obvious that because they are in the same group, they will have some common properties. Is it clear? So definitely, you know, instead of this, in the same group, you cannot use that until and unless you are able to show some efficacy in that particular line. That is, if you are using bromine instead of chlorine, it gives you excellence in that particular field. So that can be considered. Okay. And the final one is, it must be capable of industrial application. That is very important. That is, you know, you perform your experiments in a lab, okay, and then you are not able to scale up the experiments. So it's very important to scale it up. You start with a small quantity, and when you scale it up to a large quantity, you find that the experiment fails. So in that case, it cannot be patented. Is it clear? So these are the prerequisites of a patent. Okay. Then, now patent can be of 2 types. One is product or design patents, and the other one is process patents. So basically, what are these? Now, you know, product, like, you know that this HIV or AIDS, this is a deadly disease. And suppose anybody invents a medicine related to this HIV. Okay, so that becomes your product patent. Okay, and if you want to have a design patent also, you can do that. Because, you know, if you suppose in a mechanical, I have just worked in a patent, you know, I worked for a patent which was in the field of mechanical engineering. They have invented a cycle which is battery operated, you know, very frictionless, and it has got lot of facilities. Okay, so it's not, I mean to say, it's not like a conventional bicycle, it's something different. So that becomes your design patent. That is, your designed a different type of cycle. Okay. Then coming to the process patent. This is also very important. You can also patent a process. You know how you can do that? Suppose you are going to invent a medicine for cancer. Okay. So that medicine you are inventing, you are preparing that medicine, and it takes almost 24 hours for a particular dose to be prepared. Okay. Now another inventor comes, and what he does is prepares the same medicine, but the time required for preparation becomes very short. That is, suppose he prepares it within 20 minutes instead of 24 hours. Okay. So that is an innovation. So in this way, he can patent that process. Though the reactant and the products are same, but the process is different, and the process, you know, is advantageous. You have to show the advantage of the process as well. If the process is advantageous, then you can also patent that process. Okay, I hope I am audible to all of you, and whatever I have spoken till now, it is clear to everybody.
Yes, ma'am.
Okay. Then coming to patent, you know, it is an invention. It is not a discovery. Okay. Like, you know, you have Newton's law of gravitation. Newton's law of gravitation, please don't confuse. It is a discovery. It is not a invention. And the discoveries cannot be patented. Like, why? Because, you know, Newton sat under the tree, he saw a falling apple, okay, and then finally it was discovered that it is due to the law of gravitation that everything falls down, isn't it? So this law existed in nature. So nothing innovation has been done here, only it has been discovered by Newton. So such kind of discovery will not be patented. But on to the contrary, if you see the telephone invention by Alexander Graham Bell, okay, so you can find this, that there was no such concept of communication before. Was there any concept of communication so fast? Okay, so telephone has given you the communication in microsecond, isn't it? So this is an invention. This did not exist in nature before, but he was the person to invent that machine or that concept. Is it clear? So that this Alexander Graham Bell's telephone is an invention and it can be patented. Clear? Clear to all of you? Okay. Okay. Before going to the details of how to file a patent, we should know, you know, what are the things which can be patented and which are the things which cannot be patented. So scientific principles, you know, I told you all the principles which already exist in our nature, the natural laws, the natural principles. Somebody goes and gives a name to it, that will not be patented. Okay, that is already existing in nature. You have not put your creative thoughts into it. Is it clear? You've just named it. You have found it out and you've named it. It existed in nature. Now, something which is against the natural laws, it cannot be patented. Or something which is abstract, based on abstract theory, the one which you are not able to conceive, you're not able to touch it, you're not able to feel it, something very abstract theory, that also cannot be patented. Some frivolous invention, you know, frivolous, they are non-serious inventions. Like, you know, you invent something which has got a very short time effect, not a long time effect. So that those kind of inventions also cannot be patented. And something which is injurious to health, that also cannot be patented. Now, method of agriculture or horticulture. This is a very important topic because, you know, you find in the Himalayan region and all, you have a lot of herbs, okay, which has got, I mean to say, medicinal importance, isn't it? Now, these herbs, you may take, someday you may discover that the stem of the herb has got medicinal property. The same tree, the same herb, you will find the leaves have got some other medicinal property. So these cannot be patented because this is a gift of nature. It already existed in nature. Okay, so this kind of things cannot be patented. Now, method of treatment for doctors, for the pharmacists and all, this is very important. Those who are learning, those who are in the branch of pharmacy and all. So here, you know, suppose there is a medicine, okay, like aspirin. I think you know the medicine aspirin. This aspirin is actually, this is a blood thinner which is given to the patients who has got high cholesterol level and all, so that it prevents heart attack or cerebral attacks. Now, one fine day, it will be found that this aspirin is also helpful in treating cancer. So then this cannot be patented for treating cancer because this is already discovered medicine and this is for a particular disease, and this cannot be. So this method of treatment, this is called a method of treatment which cannot be patented. Okay. Coming to admixtures. Now, what are the admixtures? You know, admixtures are something like you put some materials. Okay, I mean to say randomly you put some materials. Okay, they share there is a conglomeration of properties. Okay, together without showing a composite property. So this kind of substances also cannot be patented. Like, you know, you mix sulfur. You have read, no, in your junior classes. For the students, I'm telling. Like if you mix sulfur and some iron filings, okay, you mix together, okay, and you will find that the iron is going to share its own property and sulfur will have its own property. So they are not joining together to give you a substantial different properties. So this kind of mixtures are called admixtures, and this also cannot be patented. Like traditional knowledge, you know, if you see in India, it's such a vast country and you find lot of tribes residing everywhere in India. So, you know, they have got some traditional knowledge. So that also cannot be patented. Inventions related to atomic energy also cannot be patented. And a very important part is computer programs, algorithms, they cannot be patented. You know, I've seen students, most of the research work, the students doing research work, you know what they do? By the response surface methodology and all other, you know, numerical analysis, they generate data. Okay. And they actually are of the view that this can be patented. No, it cannot be patented. Be clear in this idea that a computer program or any algorithms or mathematical or business method cannot be patented. Okay. Now, a mere finding of a new form of a known substance, like, you know that acetic acid is there. Okay, so this is a known substance. Now, suppose instead of acetic acid, I take sodium acetate, which is a salt of acetic acid. So this cannot be patented. Okay, esters, isomers, complexes. So this are actually the known substance. They are the derivatives or they are the extensions of this previously known substance, and so hence they cannot be patented. Is it clear? Okay. I don't know whether the students are listening or not. Are you listening?
Yes, ma'am.
Okay. Now, how can I get a patent in India for my project idea or concept? Okay. So, you know, this is very important for all people. For a business owner, definitely it is important because you are going to, you are going to patent a product. Okay, if you want to patent a product, business owner are always of the view to patent a product because they are going to fetch them money, isn't it? Research scientists would always like to patent their concepts, their formulas. The PhD, ME holders also, they will want their research project, and definitely, you know, students also, they will have some interest in patents because future if they can patent their inventions, they'll also fetch some money, isn't it? They'll have some money. Okay, coming to, first of all, before patenting, you have to think over. Okay, you have to ponder whether your idea, your project or product is patentable or not. I have given you in the previous slide, I've already told you what are the things which cannot be patented. Okay, so you have to see that within that list that your product comes or not. Okay, then you have to think about how to apply a patent for in India, because you can also file a patent outside India. That is a totally different area. Okay, so today we are discussing only about patenting in India. Then definitely the cost factor. What is the cost of filing a patent in India? Okay. So for all these reasons, for all these factors, you contact a patent agent or a professional who is going to explain you all these norms and also will write and file the patent for you. Okay, because you know it is a very difficult thing. That patent is a techno-legal document having certain complexities. It is not, you know, like writing a paper that you write in your research papers and all. That is totally different from writing research papers. There's some law, you have to abide by those laws. Okay, so these are some different. It is not like people generally, you know, they think, I've seen students or people from academic institutions, they think that patent, it can be, since I've written a paper, so I can also file a patent. No, it has got certain complexities. It is a techno-legal document which has to be sorted out with a patent agent or a professional or an attorney. You can also hire an attorney for that. Okay. Now, you may think that why will I waste my money in patenting all these things? Okay, so what is the motive behind patenting any invention? Okay, so the first thing is you're going to own that invention for a period of 20 years. So 20 years you're going to own that particular invention. That is your product. That is your right. Okay, you can also build your business upon that product. You can build your business upon that. You can rent it also. That is license it. Like, you know, if somebody wants your product, if somebody wants your idea, you can license it. You can give your idea, give your product in exchange for some money, which is completely decided by you. Okay, so this also will give you some advantage. Then if you want to sell it to a very big multinational, if they are going to pay you a handsome amount, then you can also sell your product. Okay, so this gives you an exclusive right over your particular invention for a period of 20 years. Okay, next, the procedures and steps for getting a patent. First, in this, we'll consider what is the cost of obtaining a patent. Okay, like if you are an individual applying for a patent, or if it is a company applying for a patent, or educational institute, all have got all different categories. Okay, and also we're going to discuss about the time which is required for getting a patent. Okay, so the step one of this is invention disclosure. So this you can also call it as complete specification. Okay, so this is actually, you know, in that file, in that invention disclosure, what are the contents? You need to have a detailed description of the invention. From what field your invention is. Is it from the chemical line? Is it from the line of physics? Is it from electronics? Okay, is it from some other branches and all? So you have to write the field of your invention. Okay, then how does it work? Your invention, giving after the field, you give the description of the invention, how your invention is working. That also you have to give. Okay, then you have to give a background of that particular invention. That is, previously somebody already has worked in this field or not. If somebody has worked, how close your invention is to his work, or rather you can say there are some weaknesses of the invention which somebody else has worked with. So you find a solution for that work. So you have crossed a hurdle and you have giving a solution to that problem, and you have discovered or you have done your own invention. Okay, so this should be filed as advantages of your invention. And then finally, if it is a mechanical or a civil or any other field, you have invented something, definitely you have to give diagrams and sketches. Okay, that should not be included in your detailed description. That should be in a separate file. Okay, and finally you have the claims. The claims, you know, it is very, very important. The claims, you know, something that is actually covering your entire invention. So these are the things that I am patenting. These are the things which I am actually keen to get the right on. So generally when we frame the claims, you know, the first claim should be done very carefully. It should be as broad, as general as possible. Okay, like, you know, I had worked with recently I worked with a patent. They have invented, you know, a cutting device for cutting the you know what, ladies finger, you know, your ladies finger, those ladies finger, they have got thorns or spines on its body. So it is very difficult for manual labor to just cut the lady's finger. It may hurt their hands. Okay. So, you know, so if you want to, they have devised, they have done, they have invented a particular cutting device which can, without any manual touching, okay, they can actually cut the lady's finger in the farm. So when you are going to frame the first claim of this, how will you frame it? You will give a generalized concept like a cutting device for harvesting crops. Now, harvesting crops may be anything. Then in your second claim, preferably you can cut the lady's finger. Preferably you can cut this. So these are going to come in your subsequent claims, but the first claim should be very broad, so that you know you have a broad spectrum on which you can file your patent. Is it clear? Clear to all of you? Now we will go for, there are two elements of cost for getting a patent. So cost is also very important. Okay. Now there is a government fees, okay, that is fixed. Okay. And then you have a professional charges, which is charged by the patent agents, professionals, attorneys, and that is variable. You know, it depends on person to person, on company to company. You'll have a lot of patent firms here which are going to charge differently. So that is not fixed. Now, for that, if you have hired a patent agent, so what are the things a patent agent is going to do? Novelty search, patent writing, patent filing, prosecution. Okay. So these are the things which the patent agent is going to do for you. And also one another assumption is that you have to, what kind of patent? You are applying for an individual patent or for a company you are applying the patent. So that is also very important. Depending on that, the cost is going to vary. Is it clear? Now, okay, so this is the step 2, and this step 2 is very important, which gives you an idea about, you know, this is a non-disclosure agreement. So what is this? This is an NDA. Now here, you know, when you are doing an invention, when you are inventing something, you are actually involving a lot of people. They may be professionals, your guides, your supervisors, your partners, your technical assistants working in the lab, and you have shared your invention with all such people. Okay. And then you discuss with your guide about the commercial aspect also of that. So now what happens? What is an NDA? It is a non-disclosure agreement, which is signed by all such people who know your invention, so that they maintain the confidentiality of your invention. Is it clear? So before going to a patent agent, the patent agent, as soon as you go to a patent agent, he will ask for this non-disclosure agreement, that whether you, the partners, the supervisors, all have signed this non-disclosure agreement. Is it clear? Then coming to the novelty and patent search. Now, this is an optional search. You know, this is generally done by the patent agent or the professionals. If you want, you can do the search by yourself also. Okay. And if you are hiring a patent agent to do the search for you, he generally takes 12,000 to 20,000 per search. And here there are no government charges. Okay. So this is an optional field. Okay, now coming to the step 4, then comes your patent filing. So there are 2 ways you can proceed for patent filing. One is the provisional patent application, and the second one is the complete patent application. Is it clear? So first we will see option 1. Okay, so option 1 is your provisional patent application. Now what is this? Like, you know, if you are in a very early stage of research, but you want your idea, your innovation to be secured. So you can secure it by applying for a provisional patent application, where your filing date are your priority dates, and that is secured. So a person A, suppose he has invented something today. Today is 12th April 2022. Now, a person B, he also actually does research in your own, in the field where person A is working, and he also invents another invention which is also in the field where person A is working. So when he is going to file the patent, if his dates clashes with the dates of the person A, then definitely the claims of the person B will be discarded, or he can use the claims of person A as a reference. So this is very important. That is why people go for provisional patent application, just to secure your you want to secure as early as possible your invention. Okay. And then is another advantage also, after you file the provisional patent application, so you get almost 12 months time to file a complete patent application. And this is very important concept, because within 12 months of filing of your provisional patent application, if you're not filing the complete patent application, then your patent gets abandoned. Is it clear? So this is very important, that before 12 months, you have to file a complete patent application. Then, if you go for provisional patent application, the cost is also low. It takes only 7 days to file it, and then 15,000 to 25,000. Here, the government fees is 1,600 only. But I told you just now that before 12 months of filing the provisional application, you need to file the complete patent application. Okay. Now, what is the option 2? Option 2 is directly you file the complete patent application. In this case, you don't have to file a provisional application. Here, the time is 15 days. It takes almost 15 days to file a provisional patent application, and the cost, you can just see, it is 25,000 to 40,000. Here also, the government fees is fixed. That is 1,600. Okay. Now, this is step 5. This is very important part, publication of the application. Now, after you have filed your patent, that is, after you have filed your complete patent application, your application will be published after 18 months from filing date. So this is mandatory. That is, it comes in the public domain after 18 months of filing. Is it clear? Now, suppose any person, he wants, no, I cannot wait for 18 months. I want to publish it earlier. So in that case, you have to fill up a form, that is Form 9, which gives you a permission of publication before 18 months of filing your patent application. And that will also cost some extra fees, that is the government fees is 2,500. So if you want your patent to come before 18 months into the public domain, then you have to pay an extra fees of 2,500, and also you have to fill up a form that is called Form 9. Clear? Okay. Now, after filing a patent, you have to file another thing that is called request for examination. So along with your patent application, you have to file request for examination. Is it clear? So ideally, this request for examination should be filed along with the patent, because after filing a patent, if you're sitting tight, nobody is going to examine your patent. It will be laying there as such. And after some time, it will be abandoned. So after you file your patent, you have to file the request for examination. That is going to charge, that will be, if it is an individual inventor, the filing fees is 4,000 rupees, 4,000. Upon receiving the request, that is RFE, the controller, you are going to submit your request to the controller of the patent office. Okay. Now the controller will pass on your patent application to the examiner. That means the person who is going to examine your patent. Okay. And the examiner now, after studying your patent, he will generate a report which is called the first examination report. The examiner generates the first examiner report, okay, and hands it to the controller, and the controller communicates the first examination report to the applicant. That means the person who has applied for the patent. Okay. Now, what happens in the first examination report? You definitely will have some objections. Okay. The objections may be regarded to the prior arts, that is already some work which has been done before in your field, and the resemblance of your work. Suppose the examiner finds that both the work are almost same, then he may raise objection regarding novelty. Now, if the examiner finds that, you know, whatever you have invented, that is very obvious, so any person skilled in that field will be able to do it, then he may raise objections in the field of inventive step. That is, he may say that this is non-obvious. Or if it is not industrially applicable, he may raise objections regarding industrial applicability. And there are some other formal objections also, but these are the three main objections which you need to know. And you know, you have to fight over it. You have to prove. Okay, what you do is you take the help of your patent agent, you take the help of your attorney, and you sort it out. All the objections should be sorted it out. And then what you do, you file a response to the FER which has been generated. Okay. So after filing an response covering all the objections, you fight over it. You say, you try to convince the controller, no, my patent is novel, my patent is inventive, and my patent also has got some industrial applicability. And then you are going to send it to the controller again. The controller will again examine it, okay, and if he is satisfied with whatever arguments you have placed, then he will grant the patent to you. So this is all about filing a patent. Thank you, students and teachers also, my colleagues, and all the dignitaries who have taken such a pain to say patience to listen to all this. Okay, thank you once again. I hand over to Shondipan.
Thank you, ma'am.
Okay.
Actually, first of all, I would like to ask to our participants if you have any query. Participants, if you have any query, you can directly ask to Dr. Jayati Biswas, ma'am. Any query? Okay, then let me say a few words about this particular webinar. First of all, ma'am, I don't think so there cannot be any question raised, because you have beautifully described all the step-by-step procedures to how to file a patent. And it is very much important for us. Basically, the IPR cell, IIC, and the NISP are very young at GKCL. All the cells were formed about 1.5 years ago. But in spite of all that, we have managed to mark some figure, mark some performance over the last 1.5 years. Till date, we have 6 patents. 2 of them are international patents we have applied, and 4 are Indian design patents and copyright. Already 1 has been granted, and others are on the verge of final examination review process. But still, as our students are coming up with various innovative ideas, we did not have any particular clear-cut idea regarding the patent filing process. But today, actually, you have beautifully described all the step-by-step process. It's really means a lot for us, ma'am.
Okay, thank you.
It's really, and we'd like to hear from you again in the future, ma'am. It's
Okay,
really wonderful. And ma'am, as a token of gesture from our end, we have prepared a data memento for you. So if you permit me, I want to share it to all the participants, in front of all the participants.
Okay, definitely permitted.
So, ma'am, can you? Is it visible,
Yes, yes, yes.
ma'am? This memento will be sent to you through your email at your email shortly.
Okay.
Thank you, ma'am. Actually, it's a great honor for us that you have described all the processes very beautifully, and you have delivered your lecture in a very short span of notice.
Okay.
Thank you, ma'am. Thank you.
Thank you
It's
so
really-
much.
It's really a great honor for us, ma'am, to have you here.
Okay. Thank you so much. And even I feel honored to give you the speech. So thank you once again.
No, ma'am. Actually, I just because even I'm the convener of IPR cell, but even I did not have this detailed knowledge of IPR filing.
Okay.
I don't know about others, but personally, I am very much, what I can't speak any, but I'm really honored, ma'am, and I'm really thankful to you, ma'am.
Okay. Once again, thank you to all of you. To all my students, okay? I don't know whether students will be
Students have stated thank you, ma'am. Students have started reading thank you.
Thank you, ma'am.
No,
okay.
actually, ma'am, the students from various departments and years, they are coming with innovative ideas, and they have and several of them have applied for grants from various organizations,
Okay.
and they are preparing for some more patents in the coming future. So I think
Okay, so even yeah, I can just tell you the farm for which I work for. So you can always go for that also. If you want any help from me in future, you can always
Definitely.
communicate me through my mail. Also, you can do it. Okay. So you are always welcome. Okay, with your ideas, with your innovative thoughts. Okay, and it is always welcome to me. I can always communicate with you.
thank you, ma'am. Thank you.
Thank you.
Thank you. And sorry, ma'am, if we have give any trouble to you.
No, I didn't find any trouble. All of you were excellently well mannered and decent. So I didn't have any trouble regarding.
Thank you.
Okay. Thank you.
Thank you, ma'am. Thank you. Okay. So with your permission, today I would like to conclude this session, and we will definitely meet in near future. Okay. Thank you, ma'am.
Okay. Thank you.
Arindam, if you are there, please end this session for today.
Yes, sir. Sandeep sir, I am only present. I'm just doing that.
One more thing, Arindam sir, if you have any query.
No, sir. It's clear. Nice present, madam. Thank you very much.
Arindam sir is our vice president of IIC, Institution Innovation Council.
Okay.
Thank you, Arindam sir,
Thank you.
for your cooperation, and I would like to thank Rajoshi sir also for his cooperation. And last but not the least, I want to thank Dr. Mahua Das, Principal GKCM, for guiding us and encouraging us to arrange such kind of events. We really need such advice from the resourceful persons time to time.
Okay.
Thank you.
Thank you.
Thank you, everyone.
Thank you, ma'am. So, Sandeep sir, just end the session.
Okay. Yes, please. And participants, the
Thank you,
feedback
Sandeep
link,
sir. Thank you.
the feedback link is shared at the chat box. Feel free to put your thoughts. Thank you. Thank you being with us today.
Thank you, sir.
Okay, Arindam sir,